outset, I would like to thank Taxmann for providing me this opportunity to address the people over a very different and apt topic, which is compounding, adjudication, and condonation under the Companies Act 2013. So I would request participants to please follow the pattern because since time is very limited, we are having only 1 hour and the topic is really very vast. So it is very difficult to cover this particular, three topics, subtopics you can say during 1 hour. It needs a lot of deliberation and discussion to happen over this, but we need to understand few things prior to the starting of the presentation. That this particular topic, if you read out that it is compounding, adjudication, and condonation under the Companies Act 2013. So first foremost thing is to understand that we have to understand whole topic only from the perspective of the Companies Act 2013 and not from any other law, because if you will go in other laws, the meaning of compounding and adjudication may differ if you compare it with the company law. Also, there are certain terminologies under the Act, Companies Act, which I will be explaining in my presentation, and which may have the different meaning in other laws. So I would request all of you to kindly understand and discuss on the topic only from the perspective of the Companies Act 2013 to be more clear and precise. So is my screen visible, Yusuf?
Yes, it is.
Okay. So now, first of all, I would like to give a disclaimer that whatever views I will be presenting in my presentation will be strictly personal. I have framed certain, posers or examples or illustrations for you people. I would request you, all of you, to, answer to those questions in the chat box so that I can also have your views and it will be exchange of knowledge, because I believe that knowledge shared is knowledge squared. And whatever views I'm giving is strictly personal, in case it may differ from your view as well. So now what we'll be covering in our presentation is, first of all, we need to understand the purpose of the Company Law Committee, because I was reading the Company Law Committee, which was formed, a report, Company Law Committee report, which was formed in 2018 and 19. And then only I, thought to have the deliberation on this particular topic, because many of the professionals were confused between the difference between the compounding, adjudication, and condonation. So we will understand the purpose of that Company Law Committee, and then we will move to understanding of certain terminologies, because this is very much important to be understood prior to dealing with sections of compounding, adjudication, and condonation. Then after, I will let you know the difference between it, and at the end, because nowadays we can see that lot of show cause notice has been issued by the Ministry of Corporate Affairs or any of the sub department of it. So what should be your thought process? This thought process is limited to my view. You may have a different thought process as well, and you may add on it to it. Okay. So this is all we are going to cover in our presentation today. So now, what is the purpose of Company Law Committee? So in 2018 and 19, the Company Law Committee was formed by Ministry of Corporate Affairs with a specific purpose to decriminalize the offense. And if you remember, in 2018 and 19, there was a lot of shift of penal provisions, and it was, the term used was decriminalization. So why this particular thought process was built? Because like, for example, let me give you an example in a very simple manner. Like, suppose the earlier what used to happen is that, suppose company has appointed Mr. X as a director and has failed to file the form DIR 12. So the penal provision was carrying the words punishable with fine, and ROC was not having power to impose fine. And what used to happen is that they used to prosecute, they used to take the particular company or the director or officer in default to the court, criminal court, and proper trial used to happen. Or simultaneously, in case company wishes to go for the compounding, they used to file the matter before the Honorable RD or NCLT whatsoever, as the case may be. And due to which the courts are overburdened with the procedural non-compliance cases, and due to which they were not able to focus on the major cases like merger, amalgamation, corporate restructuring, operation mismanagement, IVC matters, and the justice was getting delayed to the major cases. So that was the first purpose, declogging of the courts. Also, simultaneously, just for the example purpose only, I am mentioning now that suppose prosecution is getting prosecution has been launched against any director for for any procedural non-compliance in the company law, and the trial is happening before the criminal court, that director suppose wants to go outside India for some global opportunity, for exploring some global opportunity. He was not able to do so. He was facing certain difficulties while having the visa application approval. So that is just an example I am quoting, and that was hampering the ease of living of corporates and ease of doing business also. And also the procedural non-compliance cases was taking lot of time to get disposed of, whatsoever the result can may be, but that was taking a lot of time to get disposed of. And that's why the introduction of the in-house adjudication mechanism was made by virtue of section 454, and the shift of penal provision from punishable fine to liable to penalty has happened, and therein the conversion of offense of criminal nature into the civil wrong has been done. So now moving forward, so if you'll see in company law, you will see somewhere in penal provisions they are saying that punishable with fine. Somewhere they are saying that you are liable to penalty. So we need to understand the difference between the fine and penalty. So if we go by rule of interpretation, the first primemost thing we need to understand that for understanding the meaning of a word, we need to refer to the definition part of the act. If that is not provided under the definition part, then you have to go and refer to the General Clause Act. And if not, then you can go for the dictionary meaning of it. So if I talk about fine, the fine has not been defined under the Companies Act, and it has not been defined under the General Clause Act also. So fine has been defined under the, we have to refer to the meaning of the fine defined under the dictionary. So I refer to Oxford Law Dictionary or Dictionary of Law or Black Law Dictionary, whatsoever. You may refer as per your convenience. So it says that a sum of money that an offender is offered to pay on conviction by the court. So it means that proper trial has to happen before the particular court. Then court will impose the fine on the person whatsoever accused. If we talk about the meaning of penalty, again, it has not been defined under the Companies Act. It has not been defined under General Clause Act. So it is just mere a punishment imposed for breaking a law, rule or contract. Like for example, suppose you are driving a car and you cross the red light, okay, and traffic police scolds you. Now you are having two options: either you pay the challan then and there, or you argue with the police officer and you say that you have not crossed the red light, it was yellow, and that matter will be taken to the court. He will ask you to come in the court and prove yourself whatsoever. So that is the difference between the adjudication and the trial prosecution, I would say. So in short, from the Companies Act perspective, in case penal provision carries punishment of fine, it will be proper trial or prosecution. And in case the penal provision carry penalty, there is no requirement to have proper trial before the court, and authority that is ROC for the perspective of 454 will impose the penalty on you. Yes, the reasonable opportunity of being heard will be definitely given to you. So that procedure will be followed, but proper trial will not have. Okay. So that is the basic difference between fine and penalty, again from the perspective of Companies Act 2013 only. Now again coming to the meaning of default and offense. So again, default has not been defined under Companies Act 2013, but it has been defined under General Clause Act. So if you will refer to the section 3 clause 38 of the General Clause Act, it defines offense as: offense shall mean any act or omission made by any law for the time being, punishable by any law for the time being in force. So I have deliberately, crossed this particular or omission for the removal of the confusion. It is, if you refer to the dictionary meaning of it, it says merely a failure, an omission of what that which ought to be done. It means like suppose company has appointed director, but has not filed director. So it's a mere omission to file the form, but it is not that grave offense. So that is the meaning of default. Default says that a normal omission, and offense has been defined particularly that offense shall mean any act punishable by any law for the time being in force. So offense will be decided whether that offense has happened or not will be decided by the court only. So that is well defined under the General Clause Act. If you go for the Black Law Dictionary meaning of offense, it says that a crime or misdemeanor, a breach of the criminal law. So that is the meaning of offense provided under the general clause. So it is, getting synced with the definition provided under the general clause there. So it is a note which I have made for myself that every default need not be that much grave, which can lead to offense. But every offense has the ingredient of default in it, which has actually harmed the intention of the legislature or public at large. So that is the difference between default and offense. I would request participants to, keep giving your reviews in the chat box whether you are able to understand or not. And if I'm going little speedy, so let me know so that I can slow down. Okay, because I'm having little less time as has been provided by Taxmann. So I need to cover all the topics. So I'm going little fast, I know, but I will try to make you understand all the things in very clear manner. Okay. Now moving forward. So let's understand the difference between the criminal wrong and civil wrong. In criminal wrong, public at large is getting affected and society is harmed. In civil wrong, public at large is not getting affected. In by what do you mean by public at large? Let me give you an example. That suppose a murder has happened in your society, so whole society will be disturbed by that particular act. But if suppose Mr. X has not paid the money to Mr. Y, okay, that is the breach of promise between X and Y. That is not going to hamper Mr. Z or any other society member. So that is the difference. First difference between the criminal and civil wrong. Second is that in criminal wrong, proper prosecution will happen or trial will happen before the court of law. In civil wrong, normal proceeding before the concerned authority whatsoever will happen. Criminal wrong is grave and serious act. Civil wrong is technical or minor wrongs, not much serious. Like for example, non-filing of DIR 12. That is just a minor glitch. It's not a that grave offense. Okay, so fourth one is that in criminal wrong, generally state takes the action, and in civil wrong, agreed person takes the action. Like for example, Y has not been paid by Mr. X, has not been repaid the loan by Mr. X. So Y will file the suit against the X. The state is not going to make any action against Mr. X, right? Now in criminal wrong, code imposes the fine or imprisonment. In civil wrong, appropriate authority will impose the monetary punishment, whatsoever is the terminology used in. In criminal wrong, there will be requirement of the presence of mens rea. In civil wrong, there will not be any requirement of presence of mens rea. Now let me tell you one good example for understanding the mens rea. Right now, we all know that MCA V3 portal is having a lot of glitches in it. So suppose your company has your client company is raising a money from the investors, and you have to follow the process of preferential allotment. You have done all the compliances, but you are not able to file PAS 3. Okay, and that too due to the technical glitch. You have tried all the ways to remove the technical glitch, but that is not getting removed. Now company is not waiting. Company has to use the money, and company has not waited and started using the money, and later on asked you to do the compliances. Now at the time of filing of PAS 3, you have to click that yes, you have done all the compliances. Without that checkbox, you cannot file that PAS 3 with the Ministry of Corporate Affairs website. So suppose tomorrow after usage of the money, that technical glitch gets removed by the MCA fortunately, and you file that PAS 3, and tomorrow some prosecution will be launched against you, right? That you are the professional, you have said that you have done all the compliance. Section 42 says that you have not used the money after the filing of the PAS 3. So you have done the non-compliance of 42, and your company officer in default and professional who is signing the form is getting prosecuted under the court. So you may argue before the court that I was not having any guilty intention behind doing such act, because we tried all our ways to file the form, but we were facing a lot of difficulties of technical glitches, and we were not able to do so. And for how long we could not use the money, because that is going to hamper the interest of the company and the stakeholders. So in the best interest of the stakeholder and the company, you have filed the form later with when the removal of the technical glitch has happened. So by that means you can prove before the court that you are not having any guilty intention behind doing such act. But yes, you should have the evidence, you should have the documentary proof to prove such thing, you may have these screenshots of the issues which you are facing over the MCA website. So that is the difference between the presence of mens rea and not. Okay, so that is just an example I'm quoting. In my view also that I can, if suppose tomorrow something happens to me like in that way, so I will be having good stand to argue before the court. So that is just an example I'm quoting. Okay, so from the Companies Act perspective, again, criminal wrong versus civil wrong. So company law recognizes offenses punishable as fine as a criminal wrong and default punishable with liable to penalty. Sorry, liable to penalty is the civil wrong. So that is for the purpose of the company law. Okay, am I clear? Am I clear? Okay. Yusuf, do let me know if there is any comment from the participants. Okay. Now moving to compounding of offense. Now compounding has not been defined under the Companies Act. So compounding, okay, thank you Rupali for replying. And compounding has not been defined under the Companies Act. So we need to refer to the General Clause Act. It has not been defined again in General Clause Act. So the Black Law Dictionary says that it is a compromise. It is a settlement. Like suppose today I know, I am aware of the fact that I have done the non-compliance of companies, some provision of Companies Act, and that provision is compoundable in nature. We will understand which provisions are compoundable in nature or not. We will later deal with it. So instead of getting prosecuted from the side of the ROC, I voluntarily go to the ROC and say that such and such non-compliance has happened. I do not want to get prosecuted later. So I want to get this compounded and settled here now without getting prosecuted in future. So that is the meaning. That means that there is a compromise between me and the department. That is the company officer in default and the ROC department, and they later on move to the particular authority, whatsoever RD or NCLT, we will understand later, for the registration of that compounding or settlement. That is called compounding order, which I can say. So that is the meaning of compounding. And Black Law Dictionary says that a felony, the offense committed by a person who have been directly injured by a felony. Felony is the word for crime used in the USA. Agrees with the criminal that he will not prosecute him. Okay, so that is the meaning of compounding. Now moving forward. Sorry. Now there were certain changes in 441. I have not. I'm not going to read whole 441 because it will again a time consuming. It will be again a time consuming thing. I'm just going to tell you the changes. I will deal with certain provisions. I will ask you to interpret it and let me know your views later. But now let me tell you what are the changes. So in 441 earlier, the opening paragraph was using the word fine only, and now it has been changed to that the words not being with the words that not being an offense punishable with imprisonment only or punishable with imprisonment also with fine. It means suppose if you read it properly, it is now covering fine only, fine or imprisonment or both. Where the mandatory imprisonment is covering, it is not covering that. So that is the shift in the words in opening paragraph of section 441 subsection 1. Now coming to 441 subsection 6. Earlier, if any offense which was having optional imprisonment or fine or imprisonment or both, that was compoundable only with the permission of the special court, and which was having mandatory imprisonment, that was not compoundable. Now after that change has been given in 441 subsection 6, that there is no requirement of the special court for of the approval of the special court for the compounding of the offenses which is having optional imprisonment. Okay, so that is the second change. Now in short, offenses which can be compounded under Companies Act 2013 are fine or imprisonment or both. And offenses which cannot be compounded are that where there is mandatory imprisonment. Punishable is imprisonment only or punishable is fine and imprisonment. Okay, am I clear? Am I clear? Just let me know. Okay. Thank you, Rupali again. Now moving forward. Second change is in 441 subsection 1 clause B. Earlier, RD was having power to compound those offenses which were having fine up to 5 lakh. Now this limit has been increased to 25 lakh. That is the second change. Okay, so RD can compound matters which involves the fine up to 25 lakh. Okay, now this is section 441 subsection 1. Now for 1 minute, I would request you all to please read this section and give me your interpretation. You may give that in comment box. Yes. Then I will interpret in my way. Then I will let you know there are certain illustrations we will deal with. Okay. Sorry. Yes. Okay. So no requirement for regional director for compounding the offenses. Okay. I'm not able to understand the comment. Okay, so no requirement for regional lateral compounding of offenses. It's not that I'm not able to understand the comment properly, which has been given by the participant. Regional director is required to have the compounding of offense in certain cases. There is some criteria. Okay, so now let me interpret it and also let you know that what are the school of thoughts while interpreting in section 441 subsection 1. Okay, there is some comment from Partha Kamal Senji which says that instead of NCLT, now the compromise may be done by the RD. Instead of not instead of, it depends upon the threshold which of amount of fine. If it is below 25 lakh, it's yes, it can be done by RD also. So now let me tell you the interpretation of section 441 subsection as per my view. So firstly, it starts with the non-obstant clause. It says that notwithstanding anything contained in the code of criminal procedure. It means it is superseding code of criminal procedure. Any offense punishable under the act. Okay, any offense punishable under the act. Whether committed by a company or any officer thereof, not being an offense punishable with imprisonment only or punishable with imprisonment and also with fine. It means, first of all, it is overriding code of superseding code of criminal procedure. Secondly, whether that offense has been committed by the company or any officer. Thirdly, that offense should not be punishable with imprisonment only, यानी कि mandatory imprisonment नहीं होना चाहिए, or punishable with imprisonment and also with fine. If there is fine and imprisonment, then also that is not compoundable. May either before or after the institution of the prosecution. It means the prosecution may have been launched or may supposed to be launched, right? It may be launched or not launched, can be compounded. Now, first thought process comes by the tribunal, and where the limit is up to 25 lakh by the RD. Now, first school of thought is that if suppose the limit is up to 25 lakh, then only RD will do it, and tribunal is not having power to do it. And second school of thought is that there is no bar on the tribunal to compound the offense, and tribunal can compound offense of any amount. That is even of 1 rupee, the tribunal is having the power to compound the offense. Okay, Mohammed Ji is writing that can you please show the previous slide once? Yes, 1 second, sir. That this is the previous slide, I believe. Okay, so now the first school of thought is that there is no limit on the tribunal, and tribunal can compound the matter of whatsoever amount of fine, whether it is 1,000, 2,000, 10,000, 10 lakh, 50 lakh, whatsoever. But RD is having the limitation of up to 25 lakh. Second school of thought is that if suppose tribunal was to be given the power to compound an offense of any amount, then what was the use of the power of the RD? So that is the second school of thought. So that is the interpretation of section 441 subsection 1. but which is having little ambiguity. Now let me tell you, let me have some illustrations. Now X Limited was not able to hold its AGM in due time and held it with a delay of 100 days. Total fine on calculation was coming roughly around 10 lakhs, suppose. So now who is authorized to compound the offense? Tribunal or RD? I would request you to please share your views also. I would request you to share your views. RD. Parthaji is writing RD. Okay. Rupali ji is writing RD. Okay. Amresh ji is writing RD and Sushil ji is writing both. Now you know this is the ambiguity. So I will let you know. I will discuss on case law later. Let's have the illustrations first. I have mentioned one case law later in this presentation, so I will share it with you. Now whether this limit of 25 lakh prescribed has to be calculated individually or combinedly. Shivam, you were asking this question, I believe. So this is the second question. What are your views on this? Whether this limit of 25 lakh is combined or individually? Yes, combined. Okay. Okay. Any other view individually? Sushil Kumar Dalima ji is writing individually. Yes, so we can see that even in the first subsection we are having lot of ambiguities. Now let me give you the answer to the second question. It is an individual limit. Why so? Because the offense, because the accused person are separate entities. Company, officer in default, whatsoever, they are separate. And suppose tomorrow prosecution is getting launched against the company and the officer in default, they will be penalized, they will be fined separately. That is not going to be fined, they are not going to be fined combinedly. So that is where, and also as an individual, suppose the company is not going for compounding, I am the director of the company, I am the officer in default, I can go voluntarily before the authority for the compounding of the offense. So it is an individual limit. Okay, Shivam, am I clear? Okay. So now moving forward, 441 subsection 2. I will deal with illustration number 1 later with the judgment. Okay. Now 441 subsection 2. It says that okay, so if legal case is already filed before the court by ROC for prosecution for a minor technical offense like not writing of DIN by director of balance sheet, can director admit the unintentional default before the court for small mistake and ready to pay penalty to be imposed by the court in the matter instead of going for compounding and facing heavy compounding fee by RD? What is your advice? PC Janji, I will share my view with you. I am just allow me to complete the presentation first because we are having constraint of time. I will share my view with you on this particular question. Okay. So now 441 subsection 2. It says that nothing in subsection 1 shall apply to an offense committed by a company or its officer within a period of 3 years from the date on which a similar offense committed by it or him was compounded. Suppose I am getting compounding of one section today and I am not going to commit the offense in 3 years, upcoming 3 years, then it's fine. If suppose I'm committing the same offense within 3 years, then I will not be allowed to do the compounding of that particular offense which has been committed subsequently. So that is the interpretation of 441 subsection 2. And if suppose I am repeating the offense after the expiry of 3 years, so that will be considered as the press offense. So that will be compounded. That is the interpretation of 441 subsection 2. Now let's have some few illustrations. Okay, so first is, suppose company has violated section 185 for 2016-17, 17-18 and 18-19. And now they moves an application for compounding for the financial year of 2016-17 on, not for 17-18 and 18-19. Okay, so later on, after the passing of the compounding order by the Honorable NCLT or RD, whatsoever is the case may be, they realized that they have not moved the application for 17-18 and 18-19, and they moved the application then after the obtaining of the compounding order. Whether the company can do so? That is the first question. That is the first question. Okay. Sushil ji is writing yes. Okay. Any other view? Any other view? Amreshji is writing no. Okay. Okay. So let's have the second question now. Suppose company holds its AGM for 2016-17 in the year 1920 with delay, and for the financial year 17-18 and 18-19 the AGM is still to be held. It means that 1920 की AGM हो चुकी है, 17-18 18-19 की अभी होनी है. Meanwhile, the company moves an application for compounding of offense for the financial year 2016-17. It means the AGM which I conducted in 1920 with a delay for the year 2016-17, I moved an application before the authority for the compounding of that particular year. Now, NCLT or RD whatsoever has passed the order for compounding also. Now, post the compliance of such order, company conducts the AGM for the 17-18 and 18-19. Now, whether the company can go for the compounding of those offenses. Yes. Please share your views in the comment box. Okay. Right. So we need, okay, one more thing. I think Manish Jain ji is saying no, Sushil ji is saying yes. So we need to understand the, what section 441 subsection 2 is saying. It says that nothing in subsection 1 shall apply to an offense committed by a company or its officer within a period of 3 years. Now here the commission in both the illustration, the commission of offense has already happened in 2016, 17, 17, 18 and 18, 19. It is not getting committed after the compounding order. Commission has already happened earlier. Now default is making good, is becoming good after the compliance order. So we need to understand the difference between it. So in both the cases, compounding is possible. Okay. Now, fourth question. Suppose Mr. X is director of A Limited, B Limited, and C Limited. He is a director in 3 companies. Now, for the year 2022, all the companies defaulted in AGM. Now, Mr. X moved an application for compounding of A Limited and got the favorable order. Now, whether Mr. X can move the application for compounding of B and C Limited, because now the party is one, and within 3 years the offense is getting committed for the same company again. Now, whether that can be done by the Mr. X. Yes, please share your views. Rupali, yes. Okay. Also, give me your why you are saying yes. Give me a substantiating reason behind it. Yes. Okay. Any other view? Amreji is saying yes, different entity. Okay. And no, because already received compounding. Parthaji is writing. So, Parthaji, in my view, in this case, okay, the compounding is pretty much possible for Mr. X in different entities, because see, tomorrow that different entities may have committed the same offense, but maybe the facts of the cases are different. And also tomorrow, suppose ROC will prosecute, Mr. X for offense in B Limited and prosecute Mr. X for offense in C Limited. So whether Mr. X can say that whether court will understand the situation that one person is getting punished for the same offense twice, the answer is no. They will take these cases separately. So that in illustration number 4, you have to take this matter individually, company wise. So in these cases also, Mr. X is having full authority to go for the compounding. This is my limited view. Okay, but yes, you are right, sir, that Mr. X is the same petitioner, but here the facts of the case and the company is different. That is what we have to understand. Okay, now coming to question number 5, Mr. X is director of A Limited, B Limited, and C Limited. Now, for the year 2022, A Limited defaulted in holding AGM, but rest of the 2 companies did the same on time. Mr. X moved an application for compounding of A Limited, okay, and got the favorable order. Now for 2023, B Limited and C Limited defaulted in holding the AGM. That is a subsequent offense has happened in B and C Limited. Now Mr. X wants to move an application for compounding of B and C Limited, whether he can do so. Again, the answer is yes, because the company is separate. Company is separate. B Limited and C Limited are separate entities. So yes, that is my limited view. Okay, on this particular illustration, because you cannot restrain Mr. X to avail his right in different entities. So that is my view, that in both the cases Mr. X can go for compounding. Okay. Okay. Yes, Amresh ji is saying yes. Sudhir ji is saying no. Sushil ji is saying no. So that is my view, in both the cases Mr. X is allowed to go for compounding. Okay. Now this is one interesting section 451, which says that punishment for repeated defaults. It says that if a company or an officer of a company commits an offense punishable either with fine or with imprisonment, and where the same offense is committed for the second or subsequent occasion within a period of 3 years, then that company and every officer who is in default shall be punishable. First thing, twice the fine, यानी कि जो फाइन है आपके penal provision में कुछ भी अगर फाइन लिखा है, so that will be doubled, in addition to any imprisonment provided for that offense. Suppose now here the interesting fact is, suppose your penal provision is carrying fine or imprisonment. So by virtue of this section, if you read it in plain manner, the fine is going to be doubled, and if there is any imprisonment has been provided, though it is optional, it will be in addition to any imprisonment. Fine, double the fine will be in addition to any imprisonment. So that indirectly interprets that or will be read as and. So that is one interesting section 451, and that was dealt by Honorable NCLT in one matter, and that was really interesting to have that judgment over this issue. So we'll discuss it. Now, what is your view? This is penal provision. Suppose this is 185. Now this is the penal provision. What do you think? Mandatory imprisonment will come or not? By virtue of section 451. Yes. Yes. Whether mandatory imprisonment will come or not. Please share your views. Okay. Am I clear till now? Yes. Okay. So, okay. I think Sushil ji, you are giving okay. You are having the view yes. Mohammed ji is having the view no. Okay, we will deal with it. We will deal with it. There is one judgment I will discuss with you. Now, these are the illustrations. Last illustration, then we will go for the case law. Okay. So first question is that suppose X Limited has its AGM for the financial year 2016, 17, 17, 18 and 18, 19 on 30th 9, 2020. And that too along with the AGM of 1920. Now company wants to compound the offense for the said 3 financial year with respect to the delay. Whether company can do so, we have already dealt it that yes, the company can do so. But the interesting question is the second question, whether you can move the combined application for it or you have to move the separate application for it. That is the interesting question, whether you can go for the combined application or you have to move the separate application. That is the interesting question. Because why I am asking this question, because earlier combined application was getting filed, and today also we are filing the same, but NCLT has taken the view that combined application cannot be moved because there is no provision for the combined application. So 3 different offenses. Sushil Kumar Dalmeji is saying that there are 3 different offenses, and they are the same offense, I think, for the same company. 3 different years. Okay, so whether you can go for combined application or not, that is an interesting question. And what are your views, whether you can go for combined application or not? Yes or no? Or you will advise your client to go for the separate application? Separate application, as section 441 says, any offense and not all offenses. Okay, Mohammed is writing that. Partha is saying no, separate application. Okay, anything else? Anyone having the answer yes? Okay, so there is no harm in moving the combined application, but one interesting case law was there, wherein the honorable NCLT bench, New Delhi, court number 3, if I remember correctly, Honorable Justice R. Varadarajan ji was the judicial member. In this matter, Magnus Solutions Private Limited versus ROC, he has given a very different interpretation. First thing, that where the maximum amount of fine does not exceed 5 lakh. Now remember 441 subsection 1. At that time, the limit was 5 lakh. Where the maximum amount of fine does not exceed 5 lakh, only RD can compound the matter and not NCLT. First interpretation. Second, repeated default within 3 years cannot be compounded by virtue of section 441 subsection 2. जो अभी तक हम illustration देख रहे थे, we were seeing the illustration that AGM has not happened for 3 consecutive years and the combined application is getting moved. So he took the view that I cannot compound the offenses for all the 3 years. That is the second view. Third view, there is no provision for combined application, and therefore no combined application can be entertained by this tribunal. So that is the third view. Now fourth, that 451 brings mandatory imprisonment into picture, and where mandatory imprisonment provision is there, compounding is not possible. He has interpreted 451 in that manner that suppose the penal provision is having the optional imprisonment and the offense is committed for 3 consecutive years, suppose. Now in that case, that or, that is in the penal provision, fine or imprisonment has to be read as and where the mandatory imprisonment will be there, I cannot compound the offense. That was the interpretation in the matter of Magnus Solutions Private Limited. So now let me ask you people that how many of you agree with this interpretation? You may do it partially or not. Yes, Parthaji, you are writing that you don't know 1 year may be rejected. Yes, that is moving of the separate application may be a good advice, but whether you can go for the combined application, that is my question. Okay, so that was my question. Moving a separate application is definitely a good advice always, because otherwise due to one glitch of any 1 year, you won't get the compounding order for rest of the 2 years also. Your application will be rejected. That is a good point, but whether you can go for combined application or not, that is the question. Suppose if you are sure, one should be able to file combined application surely. Yes, Prashil, you are right. So now this is the judgment of Honorable NCLT, and in my view, this judgment is not interpreted in the proper manner, is not interpreting the provision in the proper manner. And in this case, if I remember correctly, more than 90 applications were rejected at once. So this was the case law, and this was later appealed before Honorable NCLT. And what was the finding of Honorable NCLT? It has reversed all the findings of Honorable NCLT, and it has said that tribunal is not having any bar. Tribunal can compound offense of any amount involving any amount of fine. RD is having the restrictions to compound the offense up to the 25 lakh, only 5 lakh. At that time it was 5 lakh, now it is 25 lakh. Okay, so that is the first interpretation. Second, that repeated default within 3 years can be clubbed for compounding in one application. Combined application can be moved. It means that there is no bar. There is no bar in moving the combined application, and rules of the court are handmaid of justice. It should not be contradictory with the notified rules, and it can be made by the different courts for their own ease of process and all. So earlier also in 1984, Department of Company Affairs has issued one circular in which they have specifically mentioned that yes, combined application can be moved for compounding of offense. And also in the case of Rajendra Prasad Gupta versus Prakash Chandra Mishra and others, combined application is allowed for same offense, and same fact was decided. So that was the first interpretation. Second finding, sorry. Third one, that any second or subsequent offense committed after the expiry, which we have read correctly when we were interpreting 441 subsection 2, it is saying that the commission of offense should happen after the compounding order, not before. If the offense has committed prior to the compounding order, then it's fine. You can go for the compounding later on also after the compounding order. But suppose you are getting the compounding order today and you are committing the offense tomorrow, then it is not compoundable. If it is committing, it has been committed within a 3 year. Okay. That is the third interpretation. Fourth is, it is apparent that unless previously the offense is compounded, the rigor of higher punishment as contemplated under section 451 would not get retracted. And it was the finding of Honorable NCLAT that NCLAT is not having power to decide such thing, that whether there will be imprisonment or not. So that is not in the powers of Honorable NCLAT, and compounding is always possible. And you should not read the provisions of section 451 in the harsh manner. That was the finding of Honorable NCLAT. And simultaneously, the fifth finding was that company is always allowed to have the compounding, because you cannot give the imprisonment order against the company. So company is always allowed to have the compounding of the offense. That was the fifth finding of Honorable NCLAT. You may go through the judgment, because I would say that you should definitely read this judgment. This judgment is really interesting, and if you will read this judgment, you will be having complete idea of the compounding section. That is one of the suggestion I would like to give you. Okay, now Makaranji is writing where multiple errors during the past are noticed today, then combining is possible. Okay, yes, right. Okay, now moving forward. Now, who will compound? Suppose offense is punishable with fine only. Who can compound? So this is very interesting to know that if fine only, then tribunal, RD, or authorized person whatsoever by the central government can compound. If fine or imprisonment is there, and fine is up to 25 lakhs, suppose, then only tribunal will be able to do it, because 441 subsection 1 is giving the power to RD to compound only those offenses where the fine is involved up to the 25 lakhs. And that is why we can understand the intention of the legislature, that he has not kept any bar on the tribunal to compound the offense. So that is the intention, because where the fine or imprisonment, penal provision carries fine or imprisonment, only the tribunal can do, not RD. So that is my my interpretation. That is my legal view. But practically we can see that in the department, the provisions which are carrying fine or imprisonment, that is also getting compounded by the RD. But in my view, that is not allowed. Okay. So however, practically speaking, Makaranji is writing, if I make a mistake today, then I cannot wait for the errors that I may or may not commit tomorrow. So I have to make the application today for the error committed. In this sense, combining of has limited application. Absolutely, Makaranji. But suppose you have not done the secretarial audit for 2 years, and you later on get to know in the third year that in the earlier 2 years also you are having the applicability of secretarial audit, and in the third year you can go for the combined application for the earlier 2 years. That is what I want to say. Thank you, Sushilji, for sharing, for giving the appreciation. Okay. Now that is why there is no bar on the limit of tribunal. Tribunal is having power to compound any offense of any amount, due to which the RD can compound only those offenses which are having the those offenses of which the penal provision is having only fine. There is no optional imprisonment, and the fine is up to 25 lakhs. If the penal provision is having optional imprisonment, the compounding is not possible by the RD. In my view. Okay. Now, where there is mandatory imprisonment, the compounding is not possible. The interesting question is, now suppose your client says that I have done some offense which is having the mandatory imprisonment, whether I can compound it or not. So if you want to go outside the company law, you can advise him to get that offense compounded under the criminal procedure code. So you can give that advice to him, or you can ask him to go for the plea bargaining. That in these two cases, these two advice you can give to your client. But that is not in Companies Act, that is in CR. Okay. Am I clear? Okay. Now moving forward, now where to move an application for compounding? You know, I was asking illustrations and everyone was saying that okay, Partha Senji, Partha Kamal Senji is saying, please clarify once again. Partha ji, I'm saying that suppose penal provision provided under the company law for any non-compliance is carrying mandatory imprisonment. It means the penal provision is carrying fine and imprisonment or imprisonment only. Whether you can do the compounding of it in company law, clearly no. But you may advise your client to explore criminal procedure code, because that criminal procedure code is also having the option of compounding. If compounding is not possible, suppose in criminal procedure code also, you may explore the option of plea bargaining. Okay, so that is one advice you may give to your client. Okay, am I clear? Am I clear? I'm not going to discuss plea bargaining and compounding under CRPC today. So am I clear? Parthaji. Okay. Now moving forward. Now where to move an application for compounding? That is one question. Whether it will be before RD, whether it will be before NCLT, or whether it will be before ROC. Because what I have observed many times that professionals are writing before the regional director, before the honorable NCLT. So that is not the correct way. If you read section 441 subsection 3A, it says that every application for the compounding of an offense shall be made to the registrar. Okay, and rule 88 says that any reference to the tribunal by the registrar, under section 441, it means the reference has to be given to the tribunal by the registrar of companies. So you have to move the application before the registrar of companies only. Okay, that is the answer to this question. We are having limited time, so I will rush quickly. Okay, now whether compounding application can be rejected? Yes, it can be rejected. Suppose there are many grounds. Suppose you are moving the application which has been application for the offense which has already been compounded earlier, and you have committed it later in the 3 years. So that is not allowed. That is one of the ground. Second, whether compounding is possible if SFIU, ED or other department proceeding is pending. In today's era, if investigation is pending under the company law, under the Companies Act, if investigation is pending, compounding is not possible. Okay, that is the answer to this question. If suppose investigation is pending under SEBI law and it is not triggering any non-compliance of the company law, then you may go for, non-compliance of the company law, then you may go for the compounding of that offense, in my view. Suppose investigation is pending under any other law, not Companies Act. So that is allowed. Whether compounding order passed by RD or NCLT can be challenged? So generally not, because that is a settlement which is getting registered before the honorable NCLT or RD. But suppose you are not happy with the compounding fees levied by the authority and you want to challenge it, you have to mention before the appropriate authority that I am happy with the rest of the order, but I am not happy with the compounding fee levied on me. So I am not settling the matter. Or if you want to still pass the order, you may mention it in the order that I may have the right, I may exercise my right to challenge this particular part of compounding order with respect to the compounding fee with the appropriate authority whatsoever. So that is one. Who shall be the authority in such case? RD or NCLT? You will be arguing, or now this question, if I am correctly understanding, you want to know that where to challenge the order of the RD or NCLT. So NCLT order is clearly challengeable before NCLT. There is an enabling provision under the Companies Act also. But for RD, there is no enabling provision. Now, this is the case which I have mentioned, MMC Dotex Services Private Limited versus ROC. In this matter, what has happened is that section 96, an application was moved by the company for extension of AGM under section 96, and that application was rejected by the ROC Chennai. Now that company moved to the honorable NCLT and requested them to pass the direction to the ROC to provide the extension. And interestingly, honorable NCLT has directed so. Though there is no enabling provision in 96 either, because 96 is giving the power to ROC to extend the time, and there is no enabling provision whether if suppose that application has been rejected, where to challenge the ROC application. But in this case, the honorable NCLT has given the direction under Rule 11, maybe, if I'm correctly remembering. So in the similar manner, taking the reference of this particular case law, I know this is not a law because this is the view of one bench only, but you may take this for reference before the argument, before the NCLT, if you are challenging the order of RD. This may give you some fruitful result, but you have to be very sure about it. Otherwise, if you want to go before the RD, against the RD order, you have to go before the High Court. Okay. Now, when compounding is not possible, in case offense is punishable with imprisonment, compounding is not possible. Imprisonment and fine both, compounding is not possible. In case investigation is pending under the Act, the compounding is not possible. In case similar offense has been compounded in 3 years, the compounding is not possible. Okay, now quickly, now prerequisite for moving the compounding application is making the offense good. So there are two sort of offense. One is the one-time default. Second one is the continuing offense. One-time default is just a secretarial audit. For example, you have not done the secretarial audit for a particular year. That is a one-time default. With example of a continuing offense can be the AGM. Per day fine is there, prescribed there. So that is a continuing offense. That per day fine will collate till the time you are not making the default good. So you have to make the default good. In case of one-time offense, the default cannot be made good because you cannot go backdated and do the secretarial audit. You may say that in the subsequent years we have made the default good. So, but in continuing offense needs to be made good mandatorily. Okay, that is the difference. Now this is all about compounding. I will quickly go for condemnation and adjudication now because already we have reached the timeline. We have crossed the timeline rather. Now condonation. It's a very interesting thing that 460 is starting with a non-obstant clause again. It says that notwithstanding anything contained in this act. It means it is overriding whole act. Now, where application required to be made to the central government under any provision of this act in respect of any matter is not made within the time prescribed, the government may, for reasons to be recorded in writing, condone the delay. Similar for the form. So suppose you have not filed any form within a time period prescribed under the law. So you may, and if you are not allowed to do so, you are not able to do so today with the additional fees, and you want to file it, you may approach the central government for getting the order of condonation. Okay, so condonation is merely allowing you to file the form with delay or the document with delay. That is the intent of section 460. Now, interestingly, section 87 of the Companies Act is also carrying the provision of condonation. Now that question arises whether, because section 87 is a specific provision, a special law, which is providing the provision for condonation of charge matters, and 460 is drafted later and with a non-obstant clause, that is notwithstanding anything contained in this act. So the first question arises whether, suppose company does not want to move a condonation application under 87, can move the application under 460. The answer is no, because 87 is giving the power to RD to deal with the charge matters, condonation of charge matters. If you will exercise 460 for those matters, then that purpose of section 87 is getting defeated. So that is the answer to that question is clearly no. You have to approach to RD only under section 87. But now today the condonation of creation of charge is not having power in 87. Now whether you can come under 460, the answer is yes. You may try your luck in 460. You may go for it. Okay. So in my view, there is no order as such still now filed. Complete justice is the subject given the time limit. Okay. So okay. So 460, in 460 you may apply your luck for condonation of creation of charge. Now, what are the obligations on the central government before approving or rejecting any application? They have to give the reasons why they are approving, why they are rejecting. Okay. Whether condonation means non-compliance has been legally forgiven, the answer is no. Suppose you are doing preferential allotment, you have not filed MGT 14, you want to file the MGT 14 with delay, you are getting the condonation order. It is just up to the purpose that you are allowed to file the form. They are not taking responsibility whether the preferential allotment process has been complied or not. And they clearly mentioned it in the condonation order also. If you read the condonation order, it is clearly mentioned over there. Okay, so that is the answer to the third question. Now adjudication will quickly come. Adjudication in simple sense means that adjudication is the process by which the authority imposes the penalty on the company or officer in default for the non-compliance, and that too done after the examining of your data. And yes, reasonable opportunity of being heard will also be given to you. Okay, now moving forward, this is very interesting that, you know, whenever show cause notice we receive any show cause notice, we generally do not pay attention properly sometimes. And you know that pursuant to the rules, rule 3, it says that such show cause notice should have the mention of the nature of the non-compliance. Second, what is the relevant penal provision for it? Third, maximum penalty which can be imposed, यानी कि penal provision में क्या maximum penalty है, and also must state the time period to show cause. It means in how much time you have to reply, and the minimum time period is 15 days and 30 days. Let me tell you, friends, that if suppose any of the thing is missing in the show cause notice, you can challenge that show cause notice upfront. You will just say that forget about the reply to the show cause notice. Let's first decide that whether show cause notice is sustainable or not. Okay, you can challenge the show cause notice. So these are the things you have to see. Now, this is one of the extract from the notice which I have received for one of my client, wherein it was written, the language of show cause notice was system generated notice, that whereas the company is also directed to serve a copy of the said notice to the director and MPs, and this notice will be treated as deemed to be served to the upon every officer in default under section 20. Now, okay, section 20 is giving that power to it, but whether this is a proper way of giving the right of opportunity of being heard, in my view, the answer is no. Because suppose tomorrow there is a management dispute, and that email ID is of the majority directors, one of the majority directors or majority shareholders, and they do not provide the information to the minority shareholder or the director whatsoever, though it will be an injustice to him. So in my view, this is a very challengeable part. And also, in the matter of Rasilal versus CWT and Union of India, Colonel J.N. Sinha, Honorable Supreme Court has said that opportunity of being heard must be given in proper spirit, and it should not be mere compliance. Okay, and it should be supplementing the law rather than supplanting the law. That was the clear verdict of Honorable Supreme Court. So you may refer this, the judgment also. I don't know how much this is going to play the role. But yes, in my view, it's going to have a very good impact over this. Okay, so that is the reasonable opportunity of being heard. Now, what are the points they will consider before passing the order? They will consider the size of the company. They will consider the nature of the business carried on by the company. Suppose your company is a textile manufacturing company, and the Corona period is going on. We all are aware that such companies has been impacted by the wave of Corona. So their business has been damaged to a lot of extent. So in that case, ROC may have the lenient view. But suppose your company is a pharmaceutical company, you are having the boom during the Corona period. So ROC may impose heavy penalty on you. Also, the injury to the public interest, nature of the default, repetition of the default, they will see, because in adjudication the repeated default can also be adjudicated, and it will be double the penalty. And also they will see that if there is any amount of disproportionate gain or unfair advantage which you have availed due to such non-compliance, or what loss you have given to the investor or the group of investor or creditors, they will examine all these things, and then only they will impose the penalty. So this is rule 3 sub rule 12. Also, proviso to rule 3 sub rule 12 says that the penalty imposed shall not be less than the minimum penalty prescribed. So that is also mentioned in the rules. Rule 3 sub rule 13 says that if there is any fixed penalty prescribed under the law, then the adjudicating officer shall impose that fixed sum only. He cannot deviate from it. That is the another interpretation. Now, what is the process? They will issue the show cause notice. Minimum 15 days time period will be given, and maximum 30 days time period will be given to file the reply. You have to submit the reply online, because the extract I have shared with you was from the MCA CMS. So that at that time the filing was done online. Today, if you are receiving any notice physically, you have to make the physical reply. If you are getting any notice through online mode, and there is an option to file the online reply, you should go for the filing of the reply through online mode. And I would say always seek an oral representation. Suppose tomorrow, why I am saying it, suppose tomorrow you will not seek an oral representation in your adjudication reply. So it is up to the authority whether they want to call you for the personal hearing or not. But if you seek the original oral representation, it will be a mandatory thing on the authority to call you for the personal hearing. So tomorrow, why I'm saying that you should mandatorily seek oral representation, because tomorrow, suppose sometimes due to your drafting or your reply is not satisfactory and they want to have more clarity on it, they may call you for personal hearing. But if you'll ask for it, they will be mandatory calling before passing the order. So that is the importance of seeking the oral representation. Okay, and within 10 days they will be calling you. And suppose they are not satisfied, and so they will be passing the order within 30 days from the date of the reply. Okay, and if they have called you for the personal hearing, then they have to shut the case within 90 days of the issue of show cause notice. So that is all about process. And now suppose if you want to challenge, okay, now that order which will be passed by the adjudicating authority must be duly dated, signed. And suppose if they have called you for the personal hearing, they have to mention particularly in the order that what was the reason they have called you for personal appearance. Okay, that is the important thing to be noted. Now suppose there are after the passing of the adjudication order, there are two options you are having. Either you can go for appeal within 60 days, you can appeal before the RD. There is a provision. And if you do not want to appeal, you have to comply with the order within 90 days by submitting the penalty imposed. So this is all about adjudication. Now let me tell you the difference between them quickly. Adjudication is a civil wrong. Again, from the company's perspective, compounding will always happen in criminal wrong. Condonation is merely getting the time to file the form, okay, or document whatsoever. Adjudication for subsequent 3 years. Suppose this same offense, the same default is happening within 3 years, then adjudication is possible, but compounding is not possible. Okay, condonation, there is no applicability as such. You may go for the condonation. Penal provision carries liable to penalty for adjudication. Condonation punishable is fine. Sorry, compounding punishable is fine. Condonation, there is no penal provision. Adjudication, the terminology used is the penalty. Compounding, the terminology used is the compounding fee. Condonation, there is no such term. And in adjudication, it is always started by the authority. Though practically we have seen that people are moving, companies moving suo motu application also. That is getting entertained by the department, because department is always benefited by the adjudication. So they are not challenging that part, since suo motu application is being moved by the company. So, but there is no provision to make this suo motu application also. But generally adjudication is started by the authority always. In compounding, it is always suo motu. Condonation is always suo motu. Adjudication, no more non-compliance will be there. Compounding, no more non-compliance will be there. But in condonation, compliance is not the guarantee. They are just allowing you to file the form with delay, and non-compliance still remains there if there is any, except for the non-filing. They will not prosecute you for the non-filing. That is fine. Okay, so that is the thought process. That is the difference between adjudication, compounding, and condonation. Now, quickly telling you that suppose you receive a show cause notice, then how you should make the reply to it. First, interpretation of law as per you. Since we have seen that when we were discussing the presentation, we were having the different views. So it may be the possibility that you are interpreting a particular section in a different manner, and authority is interpreting in different manner. So you have to particularly write in the reply that what is your interpretation. Second, Limitation Act. Suppose tomorrow ROC is going to prosecute you or adjudicate you for the matter which is, or prosecute you for the matter which has happened, for the offense which has happened in 2005, whether they can do it or not. Explore that opportunity. Request for representation. I have already mentioned that you should seek the oral representation. Deny the offense. What I have seen observed generally that, professionals are making the reply, they are mentioning all things, but they are not ever anywhere mentioning that they have not done the offense. They are not doing it right. So you have to be very particular about it. Fifth, alternate option. Suppose, in 1 year you are filing the MDT 7 and you have to attach the list of shareholder in it, but mistakenly you attach some other PDF whatsoever, not the list of shareholder. So tomorrow, suppose ROC gives you the so-called notice, and that you have not attached the list of shareholder in that particular NVD7. You may give an alternate option to them that, sir, we will file the list of shareholder for that particular year in the subsequent year. Try to give the alternate option to have the better negotiation. Now, 6, whether form is always analyzed that whether your form for on the basis of which the show cause notice is issued was STP or through approval mode. Why I am saying that? In STP mode, yes, the upper hand is of the authority, but in approval mode, you may argue that suppose DR12 removal of director. Tomorrow, you may argue that this form was approved by you, and in case you have received some resubmission, you may say that you have raised the queries, we have sorted all the queries, and after your satisfaction only you have approved the form. So you may reply that thing in the reply to the show cause notice. Last, officer in default, because what they are doing is that they are taking the name of all the directors from the master director and issuing notice to all the directors, even the independent director. So you may reply in your you may mention in your reply to the show cause notice that who are the officer in default and who are not. So you have to be very clear about it. This is all about from my side. All from my side. If there is any query, I will be happy to answer. Okay, I'm really sorry that I have taken whole presentation in a very speedy manner because there was only 1 hour and I have to cover a lot. Hope I'm able to make you understand the things in a proper manner. Okay. Okay, now PC Jain ji कह रहे हैं कि उनका reply करना है. Okay, right. PC Jain ji, let me take your query. Okay, if legal case is already filed before the court by ROC for prosecution for a minor technical offense like not writing DIN by director or balance sheet on balance sheet, can director admit the unintentional default before the court for small mistake and ready to pay penalty to be imposed by the court in the matter instead of going for compounding and facing heavy compounding fee by the RD? See, PC Janji, I would like to give you my view on this. You are right. Yes, it may be the possibility in compounding fee. In case of compounding, you may be imposed with a heavy compounding fee. In case of fine imposed by the court, it may be lesser amount. I agree with that. But you have to understand that if suppose tomorrow you are accepting that mistake before the criminal court, you will be considered as convicted in the terms of law, right? So you should not accept that. I won't advise you to go for acceptance before the criminal court. Rather go for compounding. Have the prosecution disposed of in a humbly manner, because tomorrow if fine will be imposed by the court, you will be convicted, and if your officer in default is convicted, it will impact the directorship of the company also. So that is one of the view I would like to give. Yes. Okay. Hope I'm clear, PC Janji. You are having both the options, but I would advise you to go for compounding. Am I clear, PC Janji? Thank you everyone for the appreciation. If there is any query in the question answer column, I will answer it. Sushil ji is saying that kindly explain what shall be the difference if the director is independent of full time or otherwise. The independent director is not involved in daily affairs, so they are not. They are having a limited responsibility. So it depends upon your employment agreement, or you can say the agreement which you are entering with the companies, entering with the director at the time of appointment. That is all debatable things, sir. I cannot comment over here. Yes. Okay, please share your. Okay, I'm just sharing my mobile number, sir, in the chat box. And also, although I will be sharing my last thing, credentials in the last slide also. Okay. 1 second. Right. I have done it, sir, in the chat box. Okay, so this is all from my side, and this is my credentials. Okay, I would request all of you to follow the shloka Satyam Vada Dharmam Chara. Speak the truth, abide by the law, follow the dharma. So this is one thing I am following also, and this is the motto of my institute. So I am following it before. I would request you all to please follow the same. These are my credentials. Thank you, everyone. And I think there is no other question left to be answered.